Article 17b provides for preliminary orders and the conditions for the grant of preliminary orders, that is, applications for interim relief without notice to the other party. It provides, unless otherwise agreed by the parties, a party may, without notice to any other party, make a request for an interim measure together with an application for a preliminary order, directing a party not to frustrate the purpose of the interim measure requested. The tribunal may grant a preliminary order if it considers that prior disclosure of the request for the interim measure to the party against whom it is directed risks frustrating the purpose of the measure. The test in Article 17a also applies to a preliminary order, provided the harm to be assessed under Article 17a 1a is the harm likely to result from the provisional order being granted or not. Given the extraordinary nature of preliminary orders, Article 17c provides a special regime for such orders. Immediately after the tribunal has determined an application for a preliminary order, the tribunal shall give notice to all parties of the request for the interim measure, the application for the preliminary order, if any, and all other communications, including a note of any oral communication between any party and the tribunal. The tribunal should then give an opportunity to any party against whom a preliminary order is made to present its case at the earliest practicable time and shall decide promptly on any objection to the preliminary order. A preliminary order expires after 20 days. However, the tribunal may issue an interim measure adopting or modifying the preliminary order after the party against whom the preliminary order is directed has been given notice and an opportunity to present its case. A preliminary order is binding on the parties but shall not be subject to enforcement by a court. A preliminary order does not constitute an award. Article 17b is an exception to the due process requirement that there be no ex parte communications between a tribunal and a party. Without notice applications are not allowed outside of the 2006 amendments. Therefore, preliminary orders without notice are not allowed under the 1984 model law regime. However, under the 1984 model law, it is possible for a tribunal to make a temporary order on the application of one party that is made with notice to the other party, but before hearing the other party. Such temporary orders are made pending the determination of the application for interim relief. This has similar effect to a preliminary order under the 2006 amendments, save that notice of the application is given to the other party.